Everyone, welcome to Chapter 18, where we're going to discuss the legal environment and our structure of our labor unions. So let's jump right in. By the end of the chapter, you should be able to describe conspiracy doctrine, injunction, explain a yellow dog contract, define the 1926 Railway Labor Act, the 1932 Norris LaGuardia Act, the 1935 Wagner Act, the 1947 Taft-Hartley Act, the 1959 Landrum-Griffin Act, the right to work laws as described in the textbook, and AFL-CIO, and the amalgamation and absorption. When we look at the legal environment of labor management relations, I mentioned in chapter 17 about the importance of unions and the fact that you have a lot of power structures out there that are working desperately to destroy and do away with unions in the United States. And I think it's just an absolute crime. But when you look back at why unions were actually formed, there's a lot of people that are very ignorant to the history and the use and the importance of unions for average workers. And they were first comprised of local organizations that have skilled craftspeople. So in Philly, you had shoemakers. In New York, you had printers. In Baltimore, you had tailors. You had them come together, and it created a family. It created a strength in numbers. It gave a voice to the voiceless. It gave strength to those who just felt so weak compared to their larger organizations, especially when you started getting some of these huge Goliath organizations who could easily discard you without any thought process. And so having this union protected you in so many ways. And it was very helpful for those who you're skilled in a craft, but you may not be are fluent in English. You may not have strong reading and writing skills. You may not understand the legal jargon being used. You may not even understand how you're being manipulated or what you're signing. You're being given a document, you don't know what it means. So it's been such a valuable unit and system and entity for a very long time. And they help with your job security and seeking higher wages and shortening your working hours. Some people were, working, 16, 18-hour days, and they were able to shorten them down to 8 to 10-hour days, and shortening people down from 90 hours a week to 60 hours a week to 40 hours a week. When the strike takes place is because management has failed to meet the demand of the union. And so this is where you come together with other employees and you refuse to work. You form a collective front, and it tells the employer that until you meet our needs, we won't meet yours. If you think you can do the work, then you do it without us. If you can replace this, then fine, replace us. But we are not going to work as long as you continue to devalue us and what we need in order to have higher well-being and provide for our families and to live with a sense of dignity. So in 1806, there was a shoemaker's case in Philadelphia, and that's what a cordwainer is, a shoemaker. And the jury ruled that groups of employees that banded together to raise their wages constituted a conspiracy in restraint of trade. a conspiracy in restraint of trade. It was established at that point, the conspiracy doctrine, which courts can punish a union if they deem that the means used or the ends sought by the union are illegal. So if it's not legal, it's by the way you're reaching it or how you end up with it. If it is not legal, it is considered a conspiracy, right? You're conspiring to do something illegal. You can actually punish the union for it. In 1842, in Commonwealth v. Hunt, the court decided that declared unions were not illegal per se, right? Not really illegal per se. You'll read more about that in your textbook. Now, sometimes an injunction has to come in and kick in the door, and that's what a court uses to control union activities. And the court order to stop irreparable damage being caused to the property. And this is where there's no remedy to protect the interest of the injunction-seeking party. And this is how it's done. There have been times throughout history that a union has bubbled up in intensity that has actually created a manic state of where you actually kind of have a gang mentality, and it actually can lead to violence, where you've seen union workers that have actually assaulted other employees who failed to join them in the strike, or assaulted newly hired employees who were coming in to take over for the employee who was on strike. And you've seen some union leaders who have done some gangster-like, mafia-style techniques. And we've also seen how the mafia has actually had their hands deeply interwoven into some unions. And so you've had both criminal enterprises as well as governmental influence that have tarnished what unions were meant for, and it's made it easier for the large entities that I mentioned earlier to start coming in to help destroy them. So the procedure that is followed to seek injunction is that you go to court, you file a complaint, and you state what happened, and that there's threat to property, and here's the relief that I'm requesting. And the judge is going to issue a temporary restraining order, and the threatened action is halted until a case can be heard before the judge. Well, then you have the preliminary hearing, and the judge is going to decide whether to issue the temporary injunction, and the trial ends with the decision of whether a permanent injunction should be issued. I really need the publisher to proofread these slides before they print them, because it's not a trail, it's a trial. So just know that I didn't do it. Your yellow dog contract is how your employer controls your union. It is an agreement that you as the employee and me as the employer have that restrains you from joining a labor union as a condition of employment. Now, remember I said that I was in an orientation where my employer said that we could not join or create a union, but we didn't have a written agreement to that, and it was not on any paperwork. But a yellow dog contract, if you see the case of Hitchman Cole versus Coke Company, Hitchman Cole and Coke Company versus Mitchell, where in 1917 the Supreme Court upheld the legality of these contracts. So if you actually sign an agreement that says that you won't join a labor union, and this is the only way you can work for this company, then you've signed an agreement. And that's why it's important to have someone review every piece of paper that's brought before you. Because once it's signed, it's binding. Ignorance of the law is not a defense. Okay. In 1890, we have the Sherman Antitrust Act, and that's where it made trust and conspiracies that restrain interstate commerce illegal. So you can't monopolize or try to monopolize interstate trade or commerce, and which is interesting because you're seeing these conglomerates of these huge entities that are gobbling up other companies, and there's a monopoly that is forming. Somehow they're getting away with it, maneuvering around it. I don't know. But it's intended to protect the public from abuses of these corporate monopolies. Back in the early or the mid to late 1800s, early 1900s, you'd have the railroad and other industries, coal and oil, and they were able to gobble up so much of their competition or force their competitors out of business, and then they would be the only big fish in the pond. And that created a monopoly because then everything had to go through them, so they could set their prices wherever they deemed fit, because where else are you going to go? And so that's how a lot of us feel when you think about your cable, satellite, cell phone, landline, where you're limited in options, electricity, gas, when you're limited as to who your provider is, you start to see those monopolies form. The Danbury Hatters case is a landmark case in 1908, and that's where it took the Sherman Antitrust Act and they also applied it to all unions across the board. In 1914, the Clayton Act created various sections of the act, and these two in particular, that a human being is not a commodity or article of commerce. Now, interesting enough, labor of a human being is not a commodity or article of commerce. Which totally, when you think about it, at that time in our country, we had quite a few human beings used as labor. So it's just interesting. And the dynamic is that now what we've done is we've created this system within our prisons, both for profit and not, where we are able to get around Section 6 by saying, well, they're not a commodity or article of commerce because they're inmates, right? But really, they're being used as a commodity and article of commerce. But that's for another day. Section 20, we have no restraining order or injunction shall be granted by any court of U.S. in case between an employer and employee. And we have the Duplex Printing Company versus Deering, where that said that unions were not exempt from the control of the Sherman Antitrust Act. So it's making sure to keep unions in place, in line, so that they don't try to scurry around what has been set in place for other entities. In 1926, the Railway Labor Act was set up where administrative machinery for handling labor relations within the railroad industry. Remember, I mentioned railroad earlier. And this was the first important pro-labor legislation that was put into play. So read more about that in your textbook and also research online. 1932, we have our Norris LaGuardia Act, Pro-Labor Act. This eliminated the use of yellow dog contracts and severely restricted the use of injunctions. So let's go back really quick. All right, 1917, yellow dog contracts were enforceable. 1917. 1932, they're now not. They're out. Can't do it. Right? It gave you as an employee the right to organize, to bargain with your employers on the terms and conditions of employment. You were no longer, chattel. You weren't property. You weren't just, something that you just a number. The weakness to this is that it didn't establish the administrative procedures to ensure that your rights were implemented. They left it out. Someone didn't think about it. Someone didn't look at the loopholes. Someone didn't consider the what ifs. So that's a weakness to the act. It still gave a way out for the employer. Then in 1935, we have the Wagner Act. It's a national labor relations that gave you as a worker the right to organize. It obligated management organizations to bargain both in good faith with the unions, and it also defined the legal management practices related to unions. And that's when the board was created to help administer the act itself. It prohibited employers from engaging in uncertain and unfair labor practices like interfering with, restraining you, coercing you into exercising your rights under the act, dominating, interfering, or any kind of financial contributions to a union, and discrimination in regard to hiring, firing, or any term or condition of employment to encourage or discourage membership in a union. Now, remember what I said. CEO McCovey said that we could not, if we tried to join or create a union, he would terminate us. Remember what I said to him? It's against the law. National Labor Relations Act, 1935, prohibits him as an employer from firing me if I join a union. The reason that an employer cannot make a financial contribution to a union is why? It's perfect sense. If I am then donating, if I'm contributing to the union, who's supposed to be the representative of the employees, then actually the union works for me. I now have undue influence. There's a conflict of interest. See. It also set in play where you can't discharge or discriminate against an employee for filing charges against the organization or for giving testimony under the act. It also prohibits the employer from refusing to bargain in good faith with legal representatives of the employees, and it helped to establish procedures for use in union elections and to conduct elections and investigate unfair practices through NLRB. In 1947, we have our Taft-Hartley Act, and it placed the Fed in a position to ensure that union management relations are conducted fairly by both sides. And this is what we now call the Labor Management Relations Act. Much longer than the Taft-Hartley Act, but you had, we spruce it up. We like long, drawn out things in our country. So under this act, unions were forbidden to coerce employees who don't want to join. They can't force employers to pressure employees to join. They can't refuse to bargain in good faith with an employer. They can't force an employer to pay for services that weren't performed. They are not allowed to engage in certain types of secondary boycotts. You can't sit here and do one and then all of a sudden you're going to set up shop somewhere else or set up a secondary one after we've actually worked out the details. And you can't charge excessive initiation fees for membership. So it's like if the union is for the working man and woman. Don't sit back here and you trying to charge us some top exec initiation fee like this is some country club experience. Come on now. It also, I mentioned the secondary boycotts. This issue involved other employers and the relationship between a union and an employer. And it expanded the size of NLRB to a 5-member panel that was created by the Act, and it was appointed by the President with the advice and consent of Senate that gave the authority to administer the Wagner Act. It brings in the Office of the General Counsel, which is a separate independent office, and they investigate unfair labor practice charges and present those charges with merit to NLRB. It helped to establish right to work laws that enacted within individual states under Section 14B of the Act, which also forbids various types of union security arrangements like compulsory union membership. In Figure 18.1, this was a map of the right to work states. And then you can see the forced unionism states in gray. And you see Georgia is a right to work state. And California, where I'm from, is a forced unionism state. And this was provided by the National Right to Work Legal Defense Foundation. Now, the Landrum-Griffin Act, known as the Labor Management Reporting and Disclosure Act, so long, it was enacted in 1959 to regulate labor unions, and it requires disclosure of certain finance information that the union has, and it has to be provided to the government to make sure there's a sense of transparency, no illegal doings, no illegal influence, no undue influence from any third parties, no hefty initiation fees, so on and so forth. And members are guaranteed the right to vote in the elections, oppose any incumbent leadership, and a majority affirmative vote of members by a secret ballot is required before union dues can be increased. Reports covering financial aspects of the union must be filed with the Department of Labor. And officers and employees of the unions are required to report any financial dealings that might influence union members' interest, meaning that can also mean any conflict of interest as well. And the unions are required to file a constitution or bylaws with the Department of Labor, and there are some very, very rigid formal requirements established for conducting national and local union elections. Members are allowed to bring suit against their union officials, and trusteeships can be established that allow national and international unions to take over the management of a local union. In 1978, legislation was enacted in the Civil Service Reform Act that regulates labor management relations for federal government employees, and the executive orders that were issued by the President of the United States set by a way to manage and operate the federal government agencies. The FLRA is the Federal Labor Relations Authority, and that's a 3-member panel, and that is used to administer the Civil Service Reform Act of 1978. And that includes your Office General Counsel and the Federal Services Impasses Panel that assists in resolving any kind of negotiation impasse that is taking place within the federal sector. It was established because we had unfair labor practices for the management of federal agencies and unions, and There are some areas that were subject to collective bargaining, and so it requires binding arbitration for any grievances that are unresolved in the grievance procedure, and it prohibits any strikes in the federal sector. Imagine if we had the strikes in the federal sector, so much would be shut down, and a lot of services would be shut down. Then some of our union structures. So we have our American Federation of Labor, Congress of Industrial Organizations. I told you we love our long words, AFL-CIO. And so these are our local, international, and national unions that are joined together to promote the interests of union and workers. It was created in 1955, and they just combined the two entities into one. And here's some important dates that you should really zoom in on for the labor movement. So it goes back to 1792, where you have your first local union, as I mentioned earlier, the Shoemakers Union of Philadelphia in 1833. You have your first city federation in New York, Philly, and Baltimore in 1850. You have your first national union, International Typographical Union. 1869 is the first attempt to form a federation of unions, which is the Knights of Labor. The 1886 is your formation of AFL. In 1938 is your formation of CIO. And then in 1955, the two are merged together as one. Now, we also have our craft unions, and those are only skilled workers that are included as members, and they can come into several trades such as masonry, bricklayers, plasterers, and those are our local, national, and international union. And we have our industrial unions that have both skilled and unskilled workers in a particular industry or group of industries. And under both national and international umbrellas, they operate under a constitution where you have a national convention with each local union, and then you have a field organization that has several regional or district offices that are managed by a regional director. On the city and state level, they coordinate and focus the political efforts of those local unions, and then they set up different activities that address the city federations, such as school board policies, community fundraising drives, and any public transportation problems. And then within the state federation, that is looking at the influence that political action has on our unions. With our local unions, they operate under the constitution of the national or international union that's over them, and they're affiliated directly with the AFL-CIO without being connected with a national international union. And those elected officers who carry out the union activities as a rule are guided by this. Now, the current and future developments in the labor movement, unions hold a higher percentage of government workforce members. The Department of Labor published a report indicating that 12.9% of wage and salary workers were union members in 2004. Highlights in the 2003 data show that men are more likely union members than women. African Americans more likely to be union than other groups. Approximately 4 in 10 government workers were union in 2003, compared with less than 1 in 2 that were in the private sector. And that is where my biggest concern is that as we increase the number in our government sectors, we are decreasing in our private sectors. And there are more private sector jobs than public sector jobs. Approximately 2 of 5 workers in education, training, and library are union members. Protective service occupation includes firefighters and police officers. 4 states had union membership rates over 20% in 2003, and the lowest union membership rates are in North Carolina and South Carolina, which, interesting enough, if you look at the political spectrum that's taking place in North Carolina and South Carolina, especially after our 2016 presidential race, you can see what's taking place, as I mentioned before. We look at amalgamation, and that's where union merger of two or more unions, they're roughly about the same size, form into a new union. And absorption is where you have a union merger that involves one union into a much larger one, kind of gobbles it up. Figure 18.2 is looking at our membership history as a percentage in the workforce from 1921 to 2003. You see we spiked really high around 1945. Um, it increased more right around 51. It dipped down slightly in 69, peaked back up in 75. Great year, great year. Then it starts to just sink down, 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 down. And it keeps getting lower, right? We're not going to see a spike. We're not going to see it shoot back up to that 30% level anymore. It's going to keep going down. And usually, those drops, if you look right over there at between 27 and 33, we had our Great Depression. So usually times in which our economy is not at its best, we can see those drops as well in union membership. People have lost jobs. So I don't see it spiking back up. There's been too much influence to try to do away with them, to keep them at bay. And so it'll be interesting. I would love to see an increase or at least a steady stay around the 20% range, but I don't know. So that is the end of this lecture. That wraps up chapter 18. If you have any questions, feel free to email me. Thank you.